Florida airspace is now a legal topic, not just an operational topic. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with what I believe is one of the most important legal developments for large turbine aircraft operating in Florida today. That is, access to the state is no longer simply a scheduling problem, it's a legal compliance problem. For years, many owners thought of Florida as easy business aviation geography. Multiple reliever airports, strong FBO infrastructure, familiar winter migration patterns, deep charter and management support. That description is now incomplete. Recent reporting from the NBAA and the FAA shows that Florida airspace has become a concentrated risk environment because of recurring South Florida presidential restrictions, heavy seasonal traffic, expanding air traffic control management initiatives, proposed Class C changes at Fort Myers, and periodic space operation closures tied to Cape Canaveral. In other words, the state is still a gateway for business aviation, but it is now a gateway for more moving legal parts. The first rule people need to remember is simple and non-negotiable. Section 91103 requires the pilot in command before beginning a flight to become familiar with all available information concerning that flight. That sounds ordinary until you apply it to large cabin or super mid-sized operations headed to Florida on a high-value passenger environment. At that point, NOTAM review is not clerical. It is risk allocation in real time. The second rule is even more memorable. Under Section 91-141, it prohibits operations contrary to presidential and other public figure flight restrictions published by NOTAM. NBAA reported in January 2025 that President Trump's second term brought the return of presidential TFRs over Palm Beach International Airport and South Florida, with new requirements for business aircraft operations. As of April 21st, 2026, the FAA's graphic TFR system was still showing active Florida security and VIP restrictions, including a new West Palm Beach TFR for April 24th through April 25th, 2026, and standing Palm Beach security NOTAM running through October 20th, 2026. That is that is why the subject is hot. The TFR issue is not hypothetical. It is live, recurring, and should be a significant operational consideration. Remember this, in Florida, legal trouble can begin before the engines start because the violation may be in the briefing, not the flying itself. This matters especially for large turbine aircraft because the operational consequences scale with aircraft complexity. A turbine trip into Palm Beach is rarely a casual hop. It may involve a principal, support staff, security, repositioning, a managed craft dispatch chain, and a narrow arrival window. When that trip is disrupted by VIP TFR, a route cap, a tunnel, or release time issue, the stress on the crew and scheduler rises. And stress is where legal mistakes become plausible. Recent NBAA reporting in 2026 describes Florida airspace as a funnel, with traffic from the north and west converging with departures from South Florida and the Caribbean. The same report explained that the FAA and industry task force work had produced capping and tunneling initiatives designed to keep traffic moving. That sounds technical, but the legal message is straightforward. The operational environment is now so managed that failing to account for system constraints can look less like bad luck and more like poor pre flight planning. There is another FAA, Florida-specific angle. The FAA announced in March 2026 that it's proposing to modify the Class C airspace over Southwest Florida, including International Airport at Fort Myers, because of the complexity and volume of traffic. Existing flight paths would not change, but the airspace in which pilots must interact with ATC would expand. That matters for turbine operators because large turbine activity tends to concentrate at airports where complexity already exists. Naples, Fort Myers, Palm Beach, Opelika, Fort Lauderdale Executive, and the Miami system. The legal significance is not that the sky changed. The legal significance is that the expected compliance burden changed and significantly increased. Add to that Florida's space operation overlay. FAA notices and current TFR postings continue to show space operation restrictions around Cape Canaveral issued under Section 91-143. Large turbine operators moving between South Florida, Central Florida, and the Northeast now need to think not only about weather and runway performance, but about federal security airspace, launch windows, and system management routing. The point is not to create alarm. The point is to reframe responsibility. The best FAA turbine operators now treat airspace compliance as a broad level operating discipline. They build presidential TFR review into dispatch, verify routing against current FAA and NBAA regional guidance, preserve proof of NOTAM and route review, and brief the principle that wheels up in Florida is often contingent on a federal airspace regime that may change with very short notice. And there's a second thing that should be remembered and worth noting. The aircraft may be private, but the airspace problem is public law. So when people ask for the hottest legal topic in Florida business aviation, I don't think it starts with a lawsuit. It starts with access. Because the modern Florida legal issue for large turbine aircraft is whether the operation was planned for the state that exists now, not the Florida operating environment people remember from 10 years ago. In brief, one of the hottest Florida legal topics for large turbine aircraft is the migration of airspace management into legal risk. Presidential TFRs, regional flow programs, proposed Class C expansion, and space operation closures all mean the same thing. Florida operators or Florida operations require a higher level of documented compliance discipline than many owners assume. I'd like you to take this away and remember this. In Florida, airspace has become part of the contract, part of the schedule, and part of the liability story. Thank you for your interest in this topic. This information is provided for informational purposes only and should not be construed as legal advice. Questions are always welcome. Please direct questions you may have to admin@aviationlegalcounsel.com. We look forward to assisting you with your aviation-related legal needs and addressing your questions with precision.